There you go. The Honourable Member for Haldimand-Norfolk.
Good morning, Mr. Speaker. It is my sincere pleasure to be able to speak on this Bill C-9, an act to amend the Judges Act today. As someone who's dedicated my life before politics to upholding Canada's justice system and to representing those who have been victimized, I would begin these remarks by expressing the necessity of our justice system to be transparent. This bill seeks to improve on the current judicial complaint process. It was more than 6 years ago, in 2016, that this government began the consultations on reforming the complaints process for judges. I must say that I question this government's priorities at this time, once again, that these reforms are not only now, Mr. Speaker, are these reforms coming to the floor after being introduced some 6 years ago. But I'm glad to see that this legislation is finally put forward. And I believe that with proper amendments at committee, it will make the complaints process that's inherent in this bill much stronger. The credibility of Canadian democracy and the institutions have been shaken over the last few years, Mr. Speaker. This is especially so since the onset of COVID and the profound encroachment that this government has had on the lives of the citizens, and almost at every turn. I've been deeply, deeply concerned, Mr. Speaker, about the declining state of our institutions and of our democracy. I'm concerned about the erosion of Canadian institutions, and I'm concerned that this has happened over the course of this Liberal administration. We've seen Canadians lose confidence and trust in their government, in healthcare authorities, in law enforcement, and in the media. Canada's justice system has also been tested greatly, Mr. Speaker. And during this time, its independence, its impartiality, its access, and its fairness have all been put into question. I know our system is not perfect, Mr. Speaker, and there are many issues that need to be addressed. But I must ensure that our legal system maintains the trust of Canadians, and that is part of my job as a legislator. We are fortunate that despite the Liberal government's many blunders, there's still some confidence in our system. Sadly, we see that with one hand, they are attempting to improve the rigor of the system by strengthening the judicial complaints process, while, on the other hand, they're undermining victims of crime by removing things like mandatory minimum sentences for the most violent offenses. It's imperative that we stand on guard and ensure that the pillars of our democracy are upheld, Mr. Speaker. It is imperative that we are always looking for ways to fix the weaknesses, to find the loopholes, and to strengthen the mechanisms that build trust, accountability, transparency in our justice system. There are weaknesses in our justice system, and some of them have been exacerbated by this Liberal government. This long overdue bill is a step in the right direction. This bill highlights the need to fix the weaknesses in our justice system and to also strengthen the checks and balances around how central players of our justice system, like judges, are held to account when an allegation of misconduct arises. So what does this bill do, Mr. Speaker? As I mentioned, Bill C-9 proposes changes to the Judges Act to strengthen the judicial complaints process, which was first established 50 years ago, Mr. Speaker. The Judges Act regulates judges in a number of ways. It empowers the Canadian Judicial Council, the CJC, to investigate public complaints. Judges can also be investigated upon the referral from an Attorney General of Canada or a provincial Attorney General about any conduct that is within a federally appointed judge's purview. The Canadian Judicial Council has 41 members, including all Chief Justices and Associate Justices. Under the new process proposed, the bill, there are 4 reasons in the bill that judges may be removed, including infirmity, misconduct, failure in the due execution of judicial office, or the judge is in a position that a reasonable and fair-minded individual and informed observer would consider to be incompatible with the due execution of judicial office. The bill specifically states that a federally appointed judge may be removed from office if the judge's continuation in office would undermine public confidence in the impartiality, integrity, or independence of the judge, or in their office of such an extent to which would render the judge incapable of executing the functions of judicial office. Now I'd like to turn to the topic of fixing the system, Mr. Speaker. The Canadian Judicial Council has for years publicly lamented the fact that the current system is often enormously time-consuming, expensive, and taxing on federal courts. They have called for legislative reforms, Mr. Speaker, and such forms are necessary to maintain public confidence in the administration of justice. Mr. Speaker, this is the crux of the matter, maintaining public confidence in the administration of justice. And for that, there must be a deep trust and confidence, not only in the system, but in the administrators of the system, the judges who are counted on to dispense fair and impartial decisions based on evidence in accordance with law, and who would administrate and execute those duties with the utmost confidence in the system. The only way that public confidence is maintained, Mr. Speaker, is by ensuring there's a robust process by which judges themselves are held to account. If people lose confidence in the integrity of the judiciary, then the whole system unravels. I can tell you that as a trial lawyer and someone who has held my own practice, I had confidence appearing before judges. I knew that they were qualified, they would make sound decisions, and they were committed to the rule of law. But over the past 2 years, I have been approached by many individuals who are concerned, Mr. Speaker, about our system. They've asked me things like, how could a judge that ran for the Liberal Party sit and preside over a hearing, a bail hearing of somebody who was charged in the convoy and under the Emergencies Act? Mr. Speaker, these questions bring our administration of justice into disrepute, and they highlight the need to ensure that judges are not in a conflict, Mr. Speaker. So, in closing, Mr. Speaker, I want to say that our system isn't perfect, but it aspires to apply the scales of justice to us all equally. It is logical to insist that judges be held to a higher standard than the average person, precisely because of the office they hold. Mr. Speaker, in closing, I'd like to just highlight the fact that by condemning the government on getting this legislation, I'm commending the government on getting this legislation to the floor. And I believe that if this legislation is put before committee, we could really hammer out some of the sections that need to be strengthened. Thank you.
Questions and comments? Question and commentaire. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. You know, we have the Canadian Judicial Council, and through that, the council, they had I believe it was a semi-annual meeting. It was taking place in Alberta, I believe it was. And there was concern in regards to why the legislation wasn't kind of passing through. And there is a fairly robust legislative agenda that the government has. We've attempted to get Bill C-9 through, ultimately having to go on to time allocation in order to get it through second reading. It still needs to go through the committee stage, not to mention the report and third reading. I'm wondering if the member can provide her thoughts in regards to responding to the need for passage, ultimately, of the legislation. Does she believe that the legislation should pass this year, or would the Conservative Party rather see it pass in 2023?
The Honourable Member for Haldeman-Norfolk.
Well, Mr. Speaker, I take my job very, very seriously as a legislator. It is imperative that the people who elect us know that we are not just pushing bills through, that we are passing the best bills. And for that to happen, Mr. Speaker, it means that when we have time allocation, we use that time to make sure that we improve on the bill and that we put the best bill forward, Mr. Speaker. And that is what I endeavour to do. Thank you.
Questions and comments? Question commentaire. L'honorable député de BTB.
The Honourable Member for Abitibi Bay James. I would like to thank my colleague for her speech. I think we have to respect the time for the process. I would like to talk about what happened in Val d'Or with the Justice Giroir. I'm very attuned to what happened. He was a Superior Court judge, and the time that this lasts, he was able to maintain his salary, and this is unthinkable. To think that even a judge would commit to the acts that he did, possibly selling cocaine. We have to avoid that this type of situation reproduces itself. We have to put an end to this process that takes too much time. It doesn't allow us to judge people accordingly.
The Honourable Member for Haldeman-Norfolk.
Yes, thank my honourable colleague for that comment. It is very, very true that when a judge is charged with improprieties, Mr. Speaker, they should not be rewarded by having their salary, by having their pensions continue, especially such an egregious impropriety as alluded to by the honourable member. Mr. Speaker, it is my position that a part of this bill has to be the strengthening of the clauses that would take away this privilege from judges and also take away the frustration that they can appeal and appeal and appeal and use taxpayer dollars to frustrate the system when they've been charged with an offence.
Question commentaire. Questions and comments. The Honourable Member for Port Moody Coquitlam.
Thank you, Mr. Speaker, and I thank the member for some of the comments today, and I think I heard that the Conservatives are interested in moving this forward to getting this to committee. So if I could just ask the member, Mr. Speaker, if they are committed to not slowing down, not frustrating this process and getting this to committee.
The Honourable Member for Haldeman-Norfolk.
Well, Mr. Speaker, I take deep exception to anybody's comment that would think that I or my colleagues would slow down a process. I take my job very, very seriously as a legislator, and as I said before, this is something that is very important to me. I believe this bill is very, very important to the judicial system. I have been an officer of the court as a lawyer, and I think it's very, very important that we maintain integrity in the system, and so a rigorous application of this bill is necessary, and we would continue to do that to put the best bill forward.
We do have time for a quick one. I would say the Honourable Member for Niagara Falls.
Thank you, Mr. Speaker, and thank you to my colleague from Haldeman-Norfolk for her excellent presentation. She talked about maintaining public confidence in our system. Perhaps you can further elaborate about public confidence in our justice system after 7 years of justice, of liberal policies that have kind of eroded the public's trust in our justice system.
The honourable member for Haldeman Norfolk.
Yes, I thank my honourable colleague for that very pertinent question. Mr. Speaker, there is a problem with public trust. As I said, as a lawyer, I appeared before judges and I always had the confidence of knowing that these judges were impartial. But with some of the things that we've seen over the last few years, even with how the Emergencies Act was dispensed, there is a lot of concern amongst Canadian citizens about the erosion of our institutions and in our system. And when we have violent offenders being released on the streets and frustrating the parole system, it really brings our administration of justice into disrepute.
Reprise de débat, continuing debate. The honourable member for Flanders.